Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen. Here. Assemblywoman Gonzalez. Here. Assemblywoman Hanson. Here. Assemblywoman Hardy. Here. Assemblywoman Kasama. Here. Assemblywoman Krasner. Here. Assemblywoman Marzola. Here. Assemblyman Miller. Here. Assemblywoman Wynn. Here. Assemblyman O'Neill. Here. Assemblyman Orentlicker. Here. Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler. Chairman Yeager.
Here. I think everyone is present. That means we do have a quorum. Good morning to committee members. Good morning to those joining us here in Carson City. Good morning to our guests on the Zoom and those who may be watching on the internet. Welcome to day 95 of the 81st session of the Nevada Legislature, which means we just have 25 more days to get our work done here. Time is going fast. Before we get started on this morning's agenda, just a few housekeeping matters. For those in the room with us, if you could please silence your devices. For those on the Zoom, if you could please remain on mute unless you are speaking, that would be helpful. And for everybody who is here, if you could remember to state your name each time before you speak, that'll help our committee secretaries prepare accurate minutes. We do expect courtesy and respect in our interactions with one another. We do not always agree on policy. That is perfectly acceptable. We need to make sure we're being respectful of one another, of this legislative process, and most importantly, of our legislative staff. And then finally, many members up here will be using multiple devices to access this morning's meeting, to access exhibits. So please don't see it as a sign of disrespect or inattention if members appear to be looking away at times. With those matters behind us, we're going to move to our agenda. And we're going to take the bills slightly out of order, committee. So we're going to start with Senate Bill 168 in its first reprint. So at this time, I will open the hearing on Senate Bill 168 in its first reprint. That measure revises provisions relating to cannabis. We have Senator Lang here for the first time in Assembly Judiciary Committee this session. Welcome, and I think she has Mr. Walker and Ms. Martin with her on the Zoom as well. So we'll give all of you a chance to present the bill, and then I'm sure we'll have some questions. So again, welcome, and please proceed.
Thank you, Chair, members of the committee. Good morning. I am Roberta Lang. I'm the state senator from District 7 in Clark County. Senate Bill 168 deals with curbside pickup, packaging and labeling, and modernizing how establishments maintain their delivery records. We drafted the bill's language in collaboration with the Cannabis Compliance Board. The Cannabis Compliance Board Executive Director, Tyler Klimas, is also available for questions. Matt Walker and I will trade places. He will be available to answer questions as well. And here to discuss the bill and the amendment is Lake Martin, Executive Director of the Nevada Dispensary Association, and she is on Zoom. Lake?
Good morning. Yes. Good morning, Chair Yeager, Vice Chair Wynn, and members of the committee. My name is Lake Martin, and I'm the Executive Director of the Nevada Dispensary Association. The Nevada Dispensary Association is a nonprofit trade association representing the majority of dispensary owners in Nevada, as well as cultivation, production, and distribution licensees. Briefly, I'll summarize what the bill intends to do, and then we'll go section by section. We'll cover curbside pickup first, and then move to packaging and labeling and digital records. So this bill would allow dispensaries to continue to provide curbside pickup to customers. Curbside pickup was authorized by Governor Steve Sisolak's Declaration of Emergency Directive 16, issued on April 29, 2020. The Cannabis Compliance Board provided written guidance for how dispensaries should implement curbside pickup on May 1, 2020. Initially, curbside pickup helped dispensaries comply with COVID-19 restrictions, reducing in-store capacity. As it turns out, customers really liked the convenience of curbside pickup. It is especially convenient for elderly customers or medical patients who have difficulty or prefer not to leave their car. Dispensaries asked the NDA to work on making curbside pickup a permanent feature. The CCB agreed that curbside pickup has worked out well, and the CCB and the NDA worked together on this legislation. The proposed bill language would allow for curbside pickup and authorize the CCB to adopt regulations. Those regulations will be just like what's currently being implemented under the current guidance. Some of the features of curbside pickup include designated spaces, security cameras with a direct line of sight, no one under 21 years of age may be in the vehicle, and orders must be placed in advance. The proposed language of the bill will also allow local governments to determine whether curbside is appropriate based on the location's characteristic or compliance with other local regulations. With respect to labeling, the bill removes language in the statute that would limit the ability of the CCB to make common sense reforms to the Nevada cannabis compliance regulations dealing with packaging and labeling. At the same time, none of the proposed language would alter the warnings or other information that is required to be conveyed in statute. The reason for the proposed revisions is to allow the CCB and stakeholders to develop packaging and labeling regulations that have clear, easy to understand definitions, that clearly convey safety information, and that are in line with best practices and safety standards. Many of the packaging and labeling regulations have not been updated in years, and therefore do not reflect modern production, new safety standards, or public health expertise. The current patchwork of statutory and regulatory language is confusing and duplicative, which can obscure critical safety information that ends up being buried in overly detailed text and warnings. We submitted some pictures as an exhibit to go along with our presentation, and in there you'll see some examples of some current labels on packages in stores in Nevada, followed by a picture of what they could look like if we adopted standards to make labeling more clear, consistent, and consumer-friendly. With respect to maintaining digital records, both the CCB and the industry agree that it makes sense for delivery records to be maintained in an electronic format rather than paper copies. This is a common sense update to reflect modern record keeping practices, and the CCB agrees with this language in updating the requirements as well. Now I'll go through the bill section by section. Section 1 of the bill adds specific language to NRS 678A-450, authorizing the board to adopt regulations relating to the packaging and labeling of cannabis products. The board has already adopted regulations to this effect under the authority given to the board in other sections of the statute, but this language seeks to make this all the more clear. Section 3 explicitly allows for curbside pickup at cannabis sales facility and states that the CCB shall adopt regulations necessary for implementation. Subsection 3 also provides that local governments retain authority to determine whether curbside pickup is appropriate at a particular location. Subsection 4 defines curbside pickup as the delivery of cannabis or cannabis products by a cannabis sales facility to a consumer in a motor vehicle located on the premises of the cannabis sales facility. Section 5 removes required labeling language. It moves required labeling language from 4B to 1H and removes the language affix a label. Those warnings, ingredient, and THC information do not go away. They move to the section on warnings in NRS 678B-520 sub 1. Also, both the keep out of reach of children and the amount of THC were already required by cannabis establishments in other parts of the section. So again, this section still requires that the information be conveyed on a label, but it doesn't require the production facility to convey it by affixing a label. It's a very small distinction, but removing that language affix can make the difference between having a number of labels stuck to a package or having a clear, consistent label that may be printed directly onto the packaging or on a flow wrapper. Similarly, where under subsection 7, there's a list of warnings that must be conveyed by written notification, this bill seeks to revise that language to state instead that the information shall be conveyed in a manner to be determined by the board. That's to allow the CCB to adopt regulations that factor in expertise and guidance from other jurisdictions regarding how warnings are best conveyed. Section 6 allows for delivery records to be kept in electronic format. Again, this is just modernizing the statute to allow for the digital management of records. That concludes our presentation on the bill. We're available for questions, as is the CCB, who we've worked closely with in drafting this bill. Thank you.
Thank you so much for the presentation. This brings me back to 2017, and I think that was when we first worked on the labeling issue, and it was Senator Farley and Senator Sagerblum, neither of whom are here in the building anymore, and I had the pleasure of working on some of that in the Assembly Judiciary Committee. So let me say I'm happy to see that we keep evolving into better language and a better process, and I particularly appreciate the removal of the word affix, and members, we didn't have the PowerPoint, but if you have a chance to look on Nellis, there is a brief PowerPoint there with some photos, and you will note, as noted, that most dispensaries actually do affix a very large label to the product when you buy it, and it's a little bit unwieldy, to be honest, and I think many consumers just kind of remove that and throw it out. So having the ability to actually have the information on the package, I think, is something that makes sense, and frankly, I'm a little disappointed we didn't think about that back in 2017, so thank you for the suggestion and for catching that. Committee members, do we have questions for any of our presenters on Senate Bill 168 in its first reprint? Or are we going to let them off easy this morning? We may let them off easy this morning, and I think that speaks to the work that you've done on the bill and having it in a good form over here. So again, thank the three of you for the presentation. We'll ask you to sit tight for just a moment. We'll take some testimony on the bill, and then we'll have a chance for some wrap-up remarks. So at this time, I'll take testimony in support of Senate Bill 168. Is there anybody here in Carson City who'd like to testify in support? I don't see anyone coming forward in Carson City. I don't believe we have anyone on the Zoom who would like to testify, but if I'm wrong about that, if you could unmute yourself and let me know you'd like to speak on this bill. I don't see that happening on the Zoom. BPS, could we go to the phone lines to see if there's anybody there who'd like to testify in support of Senate Bill 168?
Yes, Chair. To testify in support of Senate Bill 168, press star 9 now to take your place in the queue. And we will begin with the phone number with the last 3 digits of 111. Please press star 6 to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hi, this is Brandon Wygand. It's Brandon, last name Wiegand. I'm the Regional General Manager for the Source Dispensaries and the Source Holding. I'm speaking on behalf of Nevada Organic Remedies, Henderson Organic Remedies, and Wellness Orchards of Nevada in support of SB 168. This bill makes 2 critical changes to 2 aspects of the cannabis industry: curbside pickup for dispensary customers and packaging and labeling. NOR supports the passage of the bill because it provides a pathway to regulated curbside delivery following the expiration of existing emergency orders implemented as a result of the COVID-19 pandemic. And further, it allows the CCB to promulgate common sense packaging and labeling regulations that are much needed in the industry. Following the onset of the COVID-19 pandemic, the cannabis industry, like many others, was placed in a precarious position. Though the industry was permitted to remain open as a result of its status as an essential business, social distancing mandates and general customer apprehension limited dispensaries' abilities to service customers in store. As part of the evolving COVID-19 response, cannabis establishments were permitted to conduct previously prohibited curbside sales as part of social distancing protocols. The result has been a welcome alternative to shopping in store that customers have come to expect and appreciate, and an option that should remain following the conclusion of the pandemic. The industry has been responsible and thoughtful about rolling out curbside service in a way that protects customers, team members, and communities as a whole. Moreover, the industry has invested heavily in infrastructure and technology to support curbside operations. These investments advance our industry, and there is no reason to see these advancements end with the pandemic. The bill also provides much-needed changes to packaging and labeling by allowing the CCB to provide common sense regulations that are easily understood and applied. The current framework is wasteful and leaves customers frustrated with the amount of packaging and labels that accompany products. A running joke among our customers is that a gram of flour is accompanied by 10 grams of packaging and labels. More cost-effective, environmentally friendly options are available that will still ensure that customers are provided with all the information needed upon purchase. Dispensaries are already required to ensure that all products leave the store in a child-proof, resealable package. There's no reason why the required labeling cannot be placed within that packaging rather than affixed to the product itself, which is another source of customer frustration. The bill will allow the CCB to provide these unnecessary requirements to reflect not only a more environmentally friendly solution, but also to reflect modern production and public health expertise. Thank you for your consideration.
Thank you for your testimony and support, Mr. Wiegand. BPS, do we have anybody else on the line in support?
To testify in support of Senate Bill 168, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close testimony in support. I will now open it for testimony in opposition. Is there anyone here in Carson City who'd like to testify in opposition? I don't see anyone coming forward. I don't see any activity on the Hollywood Squares Zoom screen. BPS, could we go to the phones to see if there's any opposition there, please?
Yes. To testify in opposition of Senate Bill 168, press star 9 now to take your place in the queue. Once again, to testify in opposition of Senate Bill 168, press star 9 now. Chair, there are no callers in the queue.
Thank you, BPS. I'll close opposition testimony. I will now open it for neutral testimony. Any neutral testimony here in Carson City? I don't see neutral testimony. Anyone on the Zoom in neutral? think we have a number of folks from CCB that were here to answer questions, but want to make sure nobody wanted to offer any testimony. Okay. I see Mr. Klein is shaking his head no. Thank you. I don't know if this is the Hollywood Squares or the Brady Bunch screen. I think we need maybe nine squares to be the Brady Bunch, and I only see 6 at the moment. So I don't think we have anyone on the Zoom in neutral. BPS, could we check the phone lines to see if there's anyone there in neutral, please?
Yes. To testify in the neutral position on Senate Bill 168, press star 9 now to take your place in the queue. And again, to testify in the neutral position on Senate Bill 168, press star 9 now. Chair, there are no callers in the queue.
Thank you, BPS. I will close neutral testimony. Before we go to concluding remarks, we did have a question from Assemblywoman Krasner, so I'll let her ask her question, and then you can decide who best to answer it. So go ahead, Assemblywoman Krasner.
Thank you very much, Chair Yeager. I just had a quick question about the labeling, and I am looking at Section 5, Sub H, where you basically keep the labeling the same, except you remove the part on the label that would say the total content of THC measured in milligrams. That will no longer be on the label, and I'm wondering why. Thank you.
Lake Martin for the record. Thank you, Assemblywoman Krasner. It's only removing it because under Section 5 Sub F already requires the amount of THC on the label. So it was just a duplication in the statute that we're removing to make more clear.
So it'll still be on the label, is that correct?
That's correct, ma'am.
Thank you.
Thank you.
Okay, let me make sure we don't have any other questions. I don't see any, so at this time, whoever would like to make concluding remarks, it looks like Mr. Walker is very nicely cleaning up the table. Senator Lang, we'll give you a chance to make concluding remarks on Senate Bill 168.
Thank you so much. I want to leave you with this. This bill is not about whether you like or don't like cannabis. It's codifying what is already in the governor allowed under emergency order for curbside pickup, and it allows for the board to make adjust the regulations for labeling and so I urge you to support this bill. I think it's a good bill. It has been very successful during the pandemic, allowing people to use curbside pickup. So I urge support of this bill. Thank you, Chair.
Thank you, Senator. Ms. Martin, did you want to make any concluding remarks? Okay, I'm seeing a no. Thank you for bringing the bill. And, I didn't mention in my comments, I think curbside pickup was one of the real innovations. Unfortunately, it needed a pandemic for it to happen, but I think once it went that direction, it seems to make a lot of sense. So I appreciate the thought you've put into this bill and allowing the industry to continue to flourish in that way. And if I could ask you next, if we could take on those long CVS receipts in some way while we're at it, I think that would be helpful. So thank you so much for your presentation. And have a great rest of the day, and thanks to everyone who joined us on the Zoom this morning as well. I will now close the hearing on Senate Bill 168, and we'll go back to our agenda, and we'll take it from the top. So at this time, I'll open the hearing on Senate Bill 50 in its first reprint. Senate Bill 50 in its first reprint revises provisions relating to warrants. I will let committee members and members of the public know there is an amendment on Nellis that was brought forward by the Attorney General's office. So that is obviously a friendly amendment, but I believe it's a mock-up amendment too. So it might make sense to look at that when we are going through the bill. So welcome Attorney General Ford, Ms. Adair, and Mr. George, who's joining us on the Zoom. So we'll give you a chance to present Senate Bill 50, and then because we're Assembly Judiciary, I'm sure we'll have a few questions for you. So welcome again, Attorney General, and please proceed.
Thank you so much, Mr. Chair. If you would let me know the protocol, am I allowed to remove my mask as I testify or no?
Thank you for asking, Attorney General Ford. We do request that you keep the mask on while testifying, please.
Very well, thank you. Sorry, still a little wet. Well, good morning, Chairman Yeager and members of the committee. For the record, my name is Aaron Ford, and I am your Attorney General. Joining me virtually and in person are members of my staff. I have a few with me today. Chief of Staff Jessica Darrett to my left, First Assistant Kyle George on the screen, my Second Assistant Christine Jones-Brady, while not on the screen, is watching and can be available to the extent questions arise in her particular capacity. And thank you again for taking time this morning to hear this important bill. I'm going to break convention by starting this testimony where it usually ends, and that's by acknowledging the stakeholders who worked with us to bring this bill to this point. When this bill was introduced, we heard from stakeholders across the board regarding how this bill fell short of what it could be. But these stakeholders gave the time and expertise to shape this bill into what you see before you today. As a result of our collaborative efforts, this bill passed out of committee in the Senate unanimously and passed the Senate unanimously. The version of the bill before you today was supported by a diverse coalition that included the Nevada Sheriffs and Chiefs Association, the American Civil Liberties Union of Nevada, the Nevada Attorneys for Criminal Justice, the Nevada District Attorneys Association, public defenders, our state's largest police agencies, and police unions, including the Nevada Police Union, the Nevada Association of Public Safety Officers, and the Las Vegas Metropolitan Police Managers and Supervisors Association. I'd like to publicly thank them for working with my office and me on this bill, which is a direct response to the outcries and demands from the community for more transparency and accountability from our law enforcement agencies. The Fourth Amendment to the United States Constitution provides that, and I quote, "No warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized," unquote. A lawfully issued warrant gives law enforcement lawful authority to enter premises without the consent of those controlling the property. In practice, law enforcement officers use two methods to gain entry into premises covered by the warrant. First, via what's commonly known as a knock and announce, or second, under a no-knock warrant. A knock and announce warrant is exactly as it sounds. The police will knock on the door, announcing something along the lines of "police, search warrant," before gaining entry or being let in. A no-knock entry, on the other hand, is used by law enforcement to capitalize on the element of surprise by swiftly securing the premises before the subject has the opportunity to respond. With a no-knock entry, officers gain entry and try to control the scene before the subject has an opportunity to react. The Supreme Court of the United States has upheld the use of no-knock warrants, but the constitutionality of a practice is merely the threshold question that we must analyze. It is not the sum total of the analysis. We know that in certain circumstances, no-knock warrants can be problematic. As I mentioned a moment ago, the purpose of a no-knock warrant is to secure persons, premises, or evidence before the subject is able to respond. But from the perspective of the subject, she only knows that an armed person has violently entered her premises, and in those immediate moments, she does not know their intent. An armed subject may reasonably believe that the officers serving the warrant are home invaders and respond accordingly. The situation is rife with danger for both law enforcement and subjects. In 2017, the New York Times conducted an investigation and reported that, and I quote, "at least 81 civilians and 13 law enforcement officers died in such raids from 2010 to 2016. Scores of others were maimed or wounded," unquote. One of the most recent examples of such a tragedy is the killing of Brianna Taylor in Louisville, Kentucky. I got goosebumps as I said her name. I need not go into the details of that incident, as I'm sure all committee persons are quite familiar with it. Suffice it to say, the police were investigating Taylor's apartment, had a no-knock warrant to enter, and execution of that no-knock warrant led to Miss Taylor's death. Her death gave rise to me bringing this bill forward. The state of Nevada's largest law enforcement agencies significantly limit the usage of no-knock warrants, except in the most urgent circumstances. For example, at least one law enforcement agency generally prohibits dynamic entry, quote, "except for deliberate hostage rescue caused by immediate life rescue exigency." Sorry, excuse my pronunciation. In none of those circumstances, a no-knock warrant is not necessary. As a result of this policy, that agency has not executed a no-knock warrant in years. Another agency has similarly adopted policies that constrains when a no-knock warrant is appropriate, and requires several levels of sign-off. As with the first agency that I mentioned, in practice, no-knock warrants are extremely rare with this one too. In short, Nevada's police have done a good job of policing themselves on the use of no-knock warrants. The restraint we have seen exercised here is a result of internal policy, however, and not law. SB 50 codifies these good policies into law by providing that no-knock warrants can only issue in very limited circumstances. First, I will address the elephant in the room. I know that some are calling for a complete prohibition of the use of no-knock warrants, particularly in the light of events in Kentucky last year. But in my judgment, there may be rare examples where a no-knock warrant may be justified and needed to protect life if planned and executed appropriately. I recognize my own limitations and know that I cannot imagine every circumstance imaginable that law enforcement may face. Thus, I do not, through this bill, seek to ban no-knock warrants in their entirety. I am, however, presenting a solution today that sets up a framework that better ensures no-knock warrants are utilized as sparingly as possible, with the equally important imperatives of officer and public safety. With the chair's permission, I'd like to turn to the committee's attention to the language of the bill. The substantive matter in this bill is broken into two sections. Section 1 pertains to arrest warrants under NRS 171, and Section 2 pertains to search warrants in NRS 179. Existing law contains mandatory language that when an applicant establishes probable cause, the court must issue the arrest warrant. Section 1.1 of this bill strikes a portion of that mandatory language so that if the underlying offense is simply that the subject has failed to provide adequate identification during a stop, while operating a watercraft, or while engaging in activities regulated by the Department of Wildlife, the court has discretion to issue a summons instead of an arrest warrant. We have preserved existing language in the law that allows a district attorney to directly apply for a summons instead of an arrest warrant. Section 1.1, subsection 3 provides that a no-knock warrant can only be issued if 4 conditions are satisfied. First, a no-knock warrant should not be utilized for misdemeanor crimes, for property crimes, or simple drug possession crimes, period. Therefore, the first element of an application must satisfy is that the underlying offense is a felony that involves a significant and imminent threat to public safety. This element also requires the applicant must explain why identifying themselves as law enforcement prior to entering is likely to create a significant and imminent threat of substantial bodily harm to the officers or to others. Second, the application must articulate with specificity why there are no reasonable alternatives to a no-knock warrant. Third, the application must specify whether the no-knock warrant can be executed during the day, and if not, why it cannot be. This is consistent with existing law regarding the manner of executing a warrant. Fourth and finally, the application for a no-knock warrant must certify that the warrant will be executed under the supervision and guidance of peace officers who are trained in the execution of warrants. I want to flesh out this last point. It's a common misconception that every police officer possesses the skills necessary to execute a search warrant. Executing no-knock warrants, however, requires specialized skills and training that patrol officers may not possess. We worked closely with the Nevada Sheriffs and Chiefs Association to ensure that this language would be workable in rural jurisdictions that lack dedicated warrant execution teams. Section 1.1 subsection 6 is the product of extensive discussions regarding the enforceability of the bill. I will first note that reprint 1 did not quite capture the provisions agreed upon by the stakeholders. In recent days, we've worked with LCB to amend this language and would like to draw the committee's attention to the exhibit file before the hearing, the amendment that Chairman Yeager referenced. The District Attorneys Association, the Nevada Attorneys for Criminal Justice, the public defenders, and the ACLU, that is, folks who are generally the ones who are litigating this issue, have confirmed that the language in this exhibit is faithful to our agreement. Subsection 6 gives teeth to the bill by providing safeguards against abuse of this process. If a defendant subsequently challenges a no-knock warrant on the basis that an applicant deliberately misrepresents or omits a material fact when applying, then the reviewing court can engage in a two-step inquiry regarding the materiality of the fact at issue. First, the court will conduct what we call de novo or brand new review of the warrant application that either includes a fact that was omitted or omits the fact that was misrepresented. The court will then determine whether a no-knock warrant could have been lawfully issued if the now included or now omitted fact was in the original application. If the court determines that it should have not been issued, then the original warrant was invalid and subject to the usual consequences of an invalid warrant. This framework is consistent with that established by the United States Supreme Court in the case of Franks versus Delaware. Sections 1.2 and 1.3 pertain to the form of the warrant itself and contain no substantive provisions. Section 1.4 addresses how the no-knock warrant must be executed. First, immediately before executing a no-knock warrant, the officers on the scene must newly assess whether the circumstances that necessitated the need for a no-knock warrant at that time of the application still exists. If those circumstances no longer exist, the officers may not lawfully proceed with executing the warrant in a no-knock fashion. Second, all officers executing a no-knock warrant must wear prominent insignia that identifies them as law enforcement officers. This provision reduces the likelihood that the officers are mistaken for anything other than what they are, law enforcement officers. Third, all officers executing a no-knock warrant must wear body cameras, as provided under existing law. Fourth, officers may only use as much force as is necessary to enter the premises. This is a circumstance-specific determination that will vary according to the specific facts of a given warrant execution. Lastly, although a no-knock warrant by definition allows officers to enter without verbally identifying themselves, they must do so as soon as practicable after entering the premises. The balance of Section 1 contains technical provisions and definitions. In the interest of time, I can characterize Section 2 by simply stating that it duplicates the NRS 171 no-knock warrant arrest requirements we've just covered in the NRS 179 search warrant sections of Nevada law. I'd like to close where I started by thanking the numerous stakeholders who worked with us to bring this bill to this point. Over the past year, we've seen and heard the cries for reform. As you all know, or may know, if you're not, I want to invite you to take a look at the Justice and Injustice forums that my office put on in the immediate aftermath of the George Floyd killing. It is now available on demand on Cox. Pick up your remote and say Justice and Injustice. And you can watch several of those who participated in the drafting of this say that they were interested in doing this. I suspect you will also see some who are now opposing this on the screen during that same time period, advocating for such changes. Keep that in mind as you proceed. Over the past year, again, you've heard cries for reform. And this summer, I joined many of you in responding to those. This bill is one of the products of those conversations. We now have the opportunity to put words into action and to enact meaningful change. I want to thank the committee for hearing this important bill, and I'm happy to entertain any questions you may have. Thank you so much.
Thank you so much, Attorney General. Thank you for your work on this bill. I know it's been a long process to get where we are here today, and just let me say on behalf of the committee, I appreciate your work and your team's work. I know it was a group effort, and to all those who have participated over the last several months to get us to this place, we certainly appreciate that hard work. I know it's not always easy. It's very time intensive, but I think it shows in the product that we have in front of us. Committee members, do we have questions for Attorney General Ford on Senate Bill 50? Assemblywoman Hardy. I'll get the name right this time.
Thank you, Chair, and it's good to see you both today, and thank you for bringing this bill forward and talking about this. So I just wanted to make sure I have a couple of things that you said that I took the notes down correctly. So this is basically internal policy of law enforcement, like in Nevada already, and then this would be putting the policy in statute. Is that what you stated?
Protocol, sir, do I go through you or do I speak directly?
Attorney General, feel free to go directly unless you want the formality of going through the chair.
Thank you so much. Assemblywoman Hardy, great to see you as well. You have heard me correctly in that regard. Many, I don't know of all of our agencies, but many of our agencies, the two largest, have policies already that limit and restrict the use of no-knock warrants. But they're policies, and policies change as administrations change. And what I look to do with this is to codify what is clearly a best practice for no-knock warrants into our law so that we can have the gold standard in that regard.
Follow up. Okay, thank you. And so could you just give me an example? So as I understand, you said there's an arrest warrant and a search warrant. Those are the two different types.
Assemblywoman Hardy, I was mentioning that there were two types of warrants, no-knock warrants or knock-and-announce warrants.
Okay.
When you watch Law and Order, you'll hear them run up to the door with their insignia and their paraphernalia on, and they'll scream, "Police!" and they'll crash the door open. That's called a knock and announce, okay? Or sometimes they'll walk up and they won't say a thing, and you'll see them number to each other, 1, 2, 3, and then they'll just slam the door in. That's a no-knock warrant. It's the latter that this is addressing predominantly.
Okay, and then could you give me an example, just if this is passed, then what kind of circumstances, I know you can't cover everything, but what's a circumstance that they would want to use a no-knock warrant, or could?
Well, no, I appreciate the question. Let me answer that two ways. Let me tell you the reason why it's important that we modify or put into law what I'm suggesting here. I'm not sure, I don't know if you're familiar with the Brianna Taylor case, who was killed with the wrongful execution of a no-knock warrant. We want to avoid that, and so do our law enforcement agencies. That was the impetus behind me bringing this bill. But the reasons why they could use it, as I mentioned in the testimony, for example, would be a hostage situation, something that presents exigent circumstances that could lead to imminent bodily harm to the officers or people inside. So very far and few between, which is already the case in our state.
Okay, thank you. Yeah, I'm just, trying to learn, and like you said, it's only limited circumstances, and of course we want to protect the subjects and the law enforcement, and so just thank you for the explanation and clarification.
Absolutely. I
appreciate
think
it.
my Chief of Staff has some comments you want to add as well.
Thank you, AG. Well, I completely agree with everything Attorney General just said. Jessica Dare for the record. For a specific hypothetical situation, if a suspect has demonstrated that he or she may be violent specifically towards police officers, then if a police officer, this subject is subject to a lawful arrest warrant, then it may be appropriate, given the specific facts and circumstances regarding that subject, that a police officer, by virtue of knocking and announcing police, may then make it more dangerous for that officer to enter because that specific subject has shown specific facts and circumstances to make it more likely that that suspect may then respond violently to that officer. So in this instance, a no-knock warrant may be appropriate to protect that officer's safety when executing a warrant. But I want to be clear that in order to get a warrant, a no-knock warrant under this bill, the affidavit that the peace officer would file in order to issue a warrant would have to very explicitly and under oath testify as to why that suspect would need a no-knock warrant because of their history, and the court would then make a determination to see if that was sufficient to justify a no-knock warrant.
Thank you. That's very helpful.
Thank you. We have some additional questions. We're going to go next to Assemblyman Miller and then to Assemblywoman Summers Armstrong.
Thank you, Chair. Thank you, Attorney General and your office for bringing this very, very, very important bill. I just have a couple of questions that I think will help just for some clarity in a couple of things as I'm also learning more about our process. So I noticed in Section 2 where it talks about the summons and warrants. And please forgive me if this is a remedial question, but if we could just get some clarity on the difference in summons and a warrant, and then when it would be necessary to proceed with a no-knock warrant.
Absolutely. I see Kyle George nodding his head up north. Do you want to down south? Do you want to chime in here?
Yes, sir. For the record, Kyle George, First Assistant Attorney General. The difference between a warrant and a summons is simple. A warrant is a court order directing law enforcement to seek out and arrest a person and an individual named in the warrant. And a summons is a legal notice by the court sent directly to the person, inviting them or instructing them to appear in court on a certain date and time. So one is the person has the opportunity to voluntarily show up when commanded to do so, and the second is instructs law enforcement to seek out and arrest that person.
Thank you. So that means that they would be summoned, and then if they didn't appear, then there would be a warrant, a standard warrant issued for them for their arrest for them to appear. Is that correct?
For the record, Kyle George. It depends on which type, what the underlying crime is. In existing law, there is a provision that says the court must issue a warrant for arrest for certain trivial crimes, basically traffic violations, hunting violations, and watercraft violations, where the subject may not have had ID at the time they were stopped. What we've done in this bill is taking that out and giving the court some discretion, saying these are not public safety crimes that we're concerned about, and therefore we'll invite the person, we'll give them the opportunity to show up in court to resolve that issue. If, on the other hand, the person fails to respond to that summons, at that point, a warrant will in fact issue for their arrest, and it reverts back to the regular warrant procedure.
Okay, thank you. How many times would the warrant, because I noticed it appears that there could be multiple summons and warrants issued, so how many of those before we would move to like a no-knock?
Thank you, Assemblyman. For the record, Kyle George. Under the proposals contained within this bill, never. We do not anticipate using this bill or using no-knock warrants for misdemeanor crimes. We believe it should be reserved only for the most serious and significant crimes, which must be felonies to begin with, as well as present some risk to public safety, to officer safety, and other criteria. So under the scenario we talked about, where someone is being summoned in for a minor, perhaps traffic offense, and then fail to show up repeatedly, under this bill, a no-knock warrant should never issue from those particular circumstances, because that would not amount to a felony.
Okay, thank you. And just one more question, Chair. My page got a little confused here. I believe, well, it's subsection E, or item E. It discusses the officers must determine if any change in circumstance has been obviated. It has obviated the need for a no-knock entry. So if we could just get some context, because from what I understand, or what I may believe in the Brianna Taylor case, there is some debate on whether or not they had the person they were looking for in custody already. And so I'm assuming that this would require them to kind of do a check to make sure before they exercise another no-knock warrant that they have not already obtained the suspect. So what are the ways that they must use to determine whether or not the no-knock is still necessary?
Aaron Ford, for the record, I'm going to refer back to Kyle after I offer a preliminary remark, and I'll just say this is entirely fact-specific, Assemblyman Miller. If they walk up to the door and they recognize something on the scene that says, okay, I no longer need a no-knock warrant. It could be, as you've indicated, we just got a call saying we got the guy in custody already. But it could be something else. Maybe the door is open and and as they walked up, they saw someone. I could make up a whole bunch of scenarios in which they would need to reassess whether they need to do a no-knock warrant or not. And that's the point of this, is to ensure that they do, in fact, do a reassessment of the circumstances before executing it. But let me let Kyle speak a little bit more on that issue.
Thank you, Attorney General. For the record, Kyle George. I think that covers most of the answer to that question, Assemblyman. The one thing I would add, one other example I would add, law enforcement may show up on scene and notice the presence of children, for example. And based on that, they are no longer able to safely execute a no-knock warrant, and therefore determine at that point, perhaps the subject is not present, there are kids around, they may decide just to knock on the door and be given access into the facilities, into the premises, as opposed to executing a no-knock warrant. But I think the Attorney General really encapsulated the underlying, perhaps the best example of when circumstances would change.
Thank you. And just, are there any requirements steps that they must take before? Like, do they have to check in anywhere with any superiors or anything to see if there's been a change in circumstances in the case before they? And that's my final question. Thank you.
Aaron Ford for the record. I'm going
Kyle
to
George for the record.
Okay, Kyle George.
Go ahead, Attorney General.
I was just going to say that the affidavit requirement lays out some specific requirements that the peace officers have to go through before they can even get the no-knock warrant. The reassessment of the scene is also going to be something that is required. You know, to your specific question, whether they have to call a superior, that's not necessarily laid out as a requirement, but in the totality of circumstances, it's something that should be considered, I suspect. And I want to, again, offer Kyle George an opportunity to chime in on that.
Thank you, Kyle George for the record. Under this process, the applicants must make specific representations to the court underlying why it is necessary to have a no-knock warrant in these circumstances. So they may, for example, list 5 different reasons. If upon arriving at the scene, 2 of those are no longer there, the need for a no-knock warrant may no longer be present. So no, there is no specific requirement that they call anyone. Perhaps the people with the best knowledge are actually on scene. But one thing I would point out, the bill does require that the no-knock warrant will be executed under the guidance of a peace officer who is trained in execution of warrants. So that is one safety check. So as right prior to gaining entry, they would probably go through a checklist. Okay, this is what we represented to the court. These factors are all still present. Yes, we can still do this safely. We can now proceed, or perhaps not.
Thank you. Thank you for the time, Chair.
And Assemblyman Miller, I'll just add on because you asked the question. I think there's an important distinction. So if someone has a summons, as Mr. George indicated, telling them they need to be in court, if they don't show up in court, the judge will issue what's called a bench warrant. That's just the judge saying, I'm issuing a bench warrant. So that is a warrant, and essentially what that warrant means is if law enforcement happens to run you or encounter you, they're going to say there's a warrant, and they're going to probably arrest you. The warrants that are contemplated in Senate Bill 50, the 2 different types, these are warrants where you actually have to swear out an affidavit in front of a judge and give particular facts. So there's 2 sort of things going on. The standard bench warrant, I would say, is not as burdensome. It's just a judge saying you didn't show up, and so you're going to be arrested. But usually that does not necessarily mean law enforcement's actively looking for you. It's just if they happen to find you, they're going to arrest you. In these circumstances, whether it's an arrest warrant or a search warrant, we're talking about law enforcement taking active steps to either arrest you or to search a premises that may be associated with you. So the standards are a little bit different. Sometimes you hear those phrases interchangeably: bench warrant, arrest warrant, search warrant. They're all different. And I think the ones that we have in Senate Bill 50 are the most difficult to get because there's a direct judicial oversight, and there has to be sworn affidavits from law enforcement or prosecutors to support them. So hopefully that doesn't muddy the water and clears it up just a little bit for you. And if you have additional questions, please do feel free to ask. We're happy to walk you through all that. I have some additional questions from committee members. We'll go next to Assemblywoman Summers Armstrong.
Thank you, Chair Yeager, and thank you, AG, and your staff for being here today and for having the courage and just having the courage to bring this. It's really much appreciated. I did want to sort of ask you a little bit more probatively about Section 1.1, and in number 6, there is in A, it says if a peace officer deliberately misrepresents a material fact. We've had a case here in Nevada, Las Vegas specifically, that ended actually in the death of someone where there was a misidentification. And it was very, very sad. A young man lost his life. Do you believe that these additional requirements to substantiate the need for a no-knock warrant will help us in the future to avoid misidentification. And in that case, it was really kind of blatant. The names were the same, but the description was completely different, and someone lost their life. So how do you see these extra steps helping avoid that?
Thank you for the question, Assemblywoman Summers Armstrong. Great to see you, and I actually appreciate the question. I'm not certain that this bill would directly address an honest mistake of misidentification. What this bill seeks to do is to ensure that in the section you're talking about specifically, a peace officer should not deliberately misrepresent a material fact. In other words, they don't need to be lying, excuse my colloquialism. And if they've lied about something that is material to them receiving the affidavit in the first place, there are judicial remedies now that have been put in, and this specific provision was heavily negotiated. I'm going to just say the ACLU, for example, was like, we need to insert some language that is going to allow for some level of accountability to the extent this happens. And we worked well with the District Attorneys Association and others to come up with this language. It's language that is similar to what is in the law related to misrepresentations and what happens when affidavits are, contain misrepresentations. And so I don't know if it would have affected, for example, the circumstance you're talking about. If it was an honest, and I hate to say honest in the context of someone losing their life, but if it was not a deliberate misrepresentation of a material fact, if, for example, the name was the same and the officer knew that the person was white as opposed to black and put in black, leading to a black man's killing, this absolutely would kick in to address that. But if there were, again, if it were not a deliberate misrepresentation of a material fact, it's not likely that the circumstance would have been addressed.
Chair, may I follow up, please? Yes, please. So would this allow for judicial remedy, or are we still stuck with there only being a remedy within the confines of the
Police policy.
Police policy
It's a
and their
judicial
contract?
remedy.
Okay.
I'm sorry, I shouldn't have cut you off. Sorry for the record over there. I know I shouldn't speak over anyone. It does provide for a judicial remedy that addresses this. The warrant will be deemed to have not been validly issued in the first place, and there are subsequent consequences in the criminal legal procedures that will manifest that type of finding.
Okay, thank you. Because I think one of the things that, at least in the communities that I represent, and just throughout the state, we're seeing this, and we're hearing about this every single day. We have a person who calls in every day and gives us information. I think there's a frustration, and this is a comment and not a question, but just a follow-up comment. There's a frustration that we want to support law enforcement. We understand that there's a need for the law, but when we see things that happen that are outside the construct of what we believe is fair application of the law, there doesn't seem to be any remedy. And so, I think people just want accountability, and they want there to be clarity and results, right? If my son is out there acting up and y'all come and get him, first of all, they were raised better and they know better, and you should come and get them if they're cutting up. But if my son Brandon, who's a common name, is mistaken for someone else, and the police come and they behave in a manner that is not acceptable, we also want them to be held accountable if there's poor behavior. So we just appreciate you so much for bringing this. Thank you.
Well, thank you. Listen, I know your children. You know my children. And if either of our kids get caught up, we're going to call each other. That's how we operate. And I appreciate that comment. And I will say this. I know it was a comment, not a question. And if you will indulge me real quickly, Mr. Chair. When I brought this bill and the pattern and practice bill that you guys have already passed, it was a direct result of the outcry from the community. Our community said they wanted some accountability. They wanted transparency. We had our Justice and Injustice Forum, where we had law enforcement, both union representation and brass, so to speak. We had the ACLU, we had community members, we had everybody on the screen in the immediate aftermath of George Floyd. And here's the issue. When asked during that time, I almost called you by your first name, Assemblywoman Summers Armstrong, what could allies do because they felt our pain. I was in my own trauma and I couldn't offer anything specific. One of your colleagues reached out to me and I couldn't offer anything in specific. But what I've learned is this. Almost a year later, some of that fervor has died down. People have gotten complacent. They say one thing on the record, so to speak, and then when it comes time to support the actual policy that they say they claim to support, they won't do it. And so what we see here, what we saw in the state Senate on this bill in particular, was a unanimous vote coming out of committee, which I think tells the public that we're listening to them. We heard what you said, and not only did we hear what you're saying, we are unified in responding to it. And it came out of committee unanimously, and then it came out of the Senate floor unanimously. Pray tell if this is going to come out unanimously from this committee and hopefully from the Assembly floor as well. But these are our requirements to respond. As the top law enforcement officer in the state, I take the onus upon myself to try to present these, notwithstanding the fact that I'm getting arrows in the back from doing some of these things. It's not a bravery from my perspective, Assemblywoman, because I'm not scared of this. It's what I feel compelled to do, and I will do it irrespective of the challenges that are coming our way. So thank you for your comment, and thank you, Chair, for letting me to filibuster a little bit.
We'll go next to a question from Assemblyman O'Neill.
Thank you, Chair. Good morning, Mr. Attorney General. It's a pleasure to see you and your staff. Hopefully, we'll see you again this afternoon at the Law Enforcement Officer Memorial. I've got actually two questions, if I may. One's a curiosity question. You mentioned that there's an agency in the U.S. that does not allow no-knock warrants. What is that agency?
Senator O'Neill, great to see you as well. No, I don't think I mentioned it was an agency. I said there are some folks who are pressing for the complete abolition of no-knock warrants. That is not my effort or my desire. There may be agencies, and in fact, I believe Colorado passed a complete ban. I could be mistaken on that, but I think Colorado passed a complete ban of no-knock warrants, and other jurisdictions have done so as well. I just didn't take that approach because, again, I know my own limitations, and I cannot foresee every single instance in the world of when this may very well be needed, and so that's the reason why I didn't seek to ban it.
I must have misunderstood you, and I agree with you. A complete ban is absolutely irrational. We try to take emotion out of a lot of our actions when we make laws and deal with the facts, not the emotion, I must say.
But I'll just say reasonable minds can disagree, and I'm not chastising Colorado for banning it. That's their desire. Yeah. In their reasonable mind, they thought a ban was more appropriate than a limitation. So I don't want to be misunderstood as chastising them for doing so. I just thought in my own mind, I wanted to proceed with it.
And I agree with you on that. And so, but my real question that I want to deal with is in 1.16, and it's actually a couple questions. Right now, if a peace officer deliberately falsifies information in an affidavit for a warrant, that to me is a crime, is it not?
It's perjury.
It's perjury. So we're just, once again, codifying what's already in statute.
At some level, yes, sir. Aaron Ford for the record. At some level, yes, sir. But again, this is also indicating that in addition to a criminal charge of perjury, there is also in the process of the criminal proceeding that is occurring relative to a particular subject, there's a remedy as well. And that is that the affidavit or that the warrant that was issued for that particular subject will be declared invalid.
And that's my second question. So when you say that it becomes void, are you saying that the arrest of the individual did not occur, that he walks free, and that the process must start all over again? And also, you said that in your second section, you basically mirror. So now any evidence found is now part of the poisonous tree?
That very well could be the case. And, I don't want to speak with whole cloth on that particular issue. And I don't know if my first assistant, Kyle George, wants to chime in on this. But there are absolutely procedural ramifications for misrepresenting material facts. One of which may be, yes, indeed, the entire conviction is thrown, or the entire arrest is thrown out, and every piece of evidence that has been obtained because of the poisonous tree that you've referred to can't be used. That is current constitutional law. But there may be other iterations of ramifications that I can't articulate off the top of my head right now, that others may want to chime in on as well.
And really, that's what I want to get on the record, that void means that it did not occur. And so then the poisonous tree doctrine would come into effect.
I
Unfortunately.
see my chief of staff wanting to hit that button. Go ahead, chief.
Thank you, AG. Jessica Adair for the record. And I do want to give First Assistant Kyle George a chance to talk because he worked very hard on the amendment, and the amendment is the section that you're referring to. But the important part of that amendment is also 6B. So let's say an officer represents in their affidavit facts A, B, C, and D. Fact A is a deliberate misrepresentation. It is not true. But facts B, C, and D are true. If the court looks at that affidavit and then takes fact A out, and facts B, C, and D are sufficient to have warranted a no-knock warrant on their own, then the warrant would still be valid. But if fact A was that linchpin that tied everything together, then the court would determine that the warrant is void. So it gives the court the option, the discretion to make a decision about if this misrepresentation was gone, would I have made the same decision? And that is why this amendment is so important. And I just want to be clear that regardless, it would be a gross miscarriage of justice if a peace officer commits perjury in a misrepresentation to the court, and that peace officer is then dealt with accordingly, but the warrant was still allowed to be valid, and the person who is the subject of that warrant goes to prison. To me, that seems like it is absolutely a perversion of our judicial system. So that's what we're getting at, is to ensure that, of course, peace officers who are doing their hardest and relying on information and putting forward an affidavit that they swear to under oath is appropriate. And I do want to commend the many law enforcement organizations who worked with us on this amendment so they can be clear that their officers are held to the highest standard, but not an impossible one for mistakes that do happen honestly in this line of work, because at the end of the day, they're just people.
I appreciate it. May I follow up, Chair? Thank you. So we're talking about a no-knock warrant. Maybe the facts did not justify the no-knock, but they would have justified a search warrant, an arrest warrant. But you're saying it's void. That's what I'm trying to clarify. You're saying a no-knock is void, but a warrant would have been appropriate. Does the evidence, does the arrest become void? So we're two warrants, right, in search warrants. That's what I was just trying to clarify on that. Thank you.
Thank you, Assemblyman Jessica Adair, for the record. Thank you for that clarification, because it's an important one. The answer, I think, is yes. Even if a regular warrant, regular arrest or search warrant would have been appropriate with those facts and circumstances, would it still be void? Yes. Is that a risk that we take by putting this in this bill? Yes. But I think the more important risk is to allow deliberate misrepresentations to stand and to permit warrants to remain valid if there are deliberate misrepresentations. So I hope that clarifies the answer to your question.
It does, and I think we may agree to disagree on this. And thank you for the time. I do appreciate it, and thank you, Chair.
You're welcome, and Assemblyman O'Neill certainly would invite you to continue those discussions with the Attorney General and his staff. In the interest of time, we're going to take, I think, one more question, because we do have a lot of folks who want to testify on this bill, and I want to make sure we get through that testimony. So we're going to go to Assemblyman Orentlicker for our final question for Attorney General Ford.
Thank you, Chair. Thank you, Attorney General, for bringing this. David Orentlicker, Assembly District 20. I'd like to follow up on Assemblywoman Summers Armstrong's question. And as you point out, people make mistakes. And we're not going to punish somebody for a mistake. But when I think about all the changes in the healthcare setting to prevent the mistakes from happening, all the double checks they do to make sure I'm David Orentlicker or you're Aaron Ford before we take your blood or cut off your foot, are there things that you all do to double check to make sure it really is a valid arrest, no-knock warrant or other warrant, and so that if there's a mistake, an innocent mistake, you catch it before you issue the warrant?
Thank you for the question, Assemblyman Orentlicker. I think the answer is contained within the final requirement that says they have to reassess the situation before executing on the no-knock warrant, right? And while this bill and the law would not dictate necessarily every single action item that a law enforcement officer would have to undergo in order to ensure that everything is lined up with all the, it does require a final assessment of the facts. And I think as Kyle George indicated earlier, and maybe I indicated this earlier, it very well could be a last-minute phone call from a supervisor saying, actually, wrong house, go next door, or actually, we got the guy in custody. Those are the types of things that, in practice, would be occurring on the ground, and it's required by purposes under this statute that they do assess before executing the no-knock warrant. I don't know if Mr. George wants to offer any additional thoughts on that.
Thank you, Attorney General Kyle George, for the record. Just to kind of clarify, I'm sorry, not clarify, I just wanted to follow with one point in this. The reason we brought this bill is because of the gravity of a no-knock warrant. We don't mean to undermine the regular warrant process anyway, but when we seek and execute a no-knock warrant, we should be held to a higher standard, and that's what this bill brings. We understand that it may put additional burdens on law enforcement in some way, but one of the things we vetted with them before bringing this bill forward in this form is to ensure that none of this is unworkable for the professionals who actually are on the ground executing these warrants. To the question of whether there's a last-minute check, every officer should be doing that anyway when executing these high-risk warrants because of the potential danger to public safety and officer safety. So I do think, as a matter of practice, the trained professionals who execute these specialized warrants will do so just to ensure one last time that everyone is as safe as possible before this is executed. I don't think I have anything further to add on that.
David Orentlicker, for the record. That's reassuring. In other settings like healthcare, they will have protocols written. Here are the things you have to do. Check them off. And if we're not doing that, it might help prevent the innocent mistakes.
Is the for the record, is the protocol you're referencing in the medical context a matter of policy, or is it something written into the law that says that they have to check all of these before they amputate?
My guess is it's part of policy, but there may also be part of accreditation requirements. So, but given life and death here too, it might be worth putting into law.
Okay, committee members, I think we're going to end questions there. There may have been some additional questions, but I'll ask you to follow up offline as we have another bill still to hear, and I want to make sure we can get through some testimony on this one. So thank you, Attorney General Ford. Thank you, Ms. Adair and Mr. George. We're now going to take testimony on the bill. I'm going to open it up for testimony in support of Senate Bill 50. And I'm going to start here in the room in Carson City. Is there anyone who'd like to come forward for support testimony? Ms. Noble, please come forward. And welcome to Assembly Judiciary. I think this is your first time in person. It's hard to remember at this point who's been here in person, but I think this is your first time, so welcome and please go ahead.
Thank you, Mr. Chair and members of the committee. My name is Jennifer Noble. I'm a Chief Deputy District Attorney in the Washoe County District Attorney's Office. And I also represent the 17 elected district attorneys of Nevada, the Nevada District Attorneys Association, and we are here today in full support of Senate Bill 50. I don't want to take up a lot of your time. I know a lot of questions have been asked, But I want to thank Attorney General Ford, Kyle George, and Jessica Adair for really bringing together a very diverse group of stakeholders and not locking us in a room, but putting us in a room all day. They did feed us pizza, and there was coffee, but we were in there for the duration, thanks to vaccines and masks. And the result is the bill that you see before you. It is the true result of good faith participation by everybody, and I urge you to support it. Thank you.
Thank you for your testimony, Ms. Noble. Ms. Brown, did you want to testify in support as well? Please come forward.
Anya Brown, advocates for the inmates and the innocent. We support this bill. It is good legislation. It's long overdue. We want to thank the sponsors of this bill. I just want to touch on, if this bill existed throughout the country years ago, a lot of people's lives would have been saved. I have a friend whose son was killed by a no-knock warrant. He had been growing a couple of marijuana plants. The police broke in early in the mornings. He thought somebody had broken in. He didn't know what was going on. He brought his gun out, and he was shot and killed in his hallway outside his bedroom door. Some years ago, Reno PD showed up at a home. The neighbors had called the police. The police showed up. They knocked on the door. Mr. Povia opened the door. He did not want to speak to the officers, and he shut the door. They opened fire on him and killed him. And so perhaps things like this can be prevented. But yes, we are in strong support of this bill. Thank you.
Thank you for your testimony, Ms. Brown. And we don't have anyone else in the room. We don't have anyone on Zoom, but I wanted to let the committee know on Nellis there are a number of letters in support, and I wanted to list those off. So we have letters in support from the Progressive Leadership Alliance of Nevada, Make It Work Nevada, the ACLU of Nevada, the Clark and Washoe County Public Defender's Office, and Battleborn Progress. And the reason they have submitted those letters in support rather than testify is they wanted to make sure that affected family members would have time to testify on the phone today, given our time constraints. So I want to thank those organizations for putting their comments in writing. I don't know that we've ever had that happen before in Assembly Judiciary, but I certainly appreciate your willingness to do that and to provide affected community members a chance to weigh in. So at this time, BPS, we're going to go to the phone line and take testimony in support there, please.
Thank you, Chair. To testify in support of Senate Bill 50, press star 9 now to take your place in the queue. And we will start with the caller with the last 3 digits of 196. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chairman Yeager, members of the Assembly Judiciary Committee. I'm Eric Spratley, S-P-R-A-T-L-E-Y, for the Nevada Sheriffs and Chiefs Association, here in support of SB 50. Thank you.
Thank you for your testimony, Mr. Spratley. BPS, next caller, please.
Next, we will go to the caller with the last 3 digits of 602. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, members of Assembly Judiciary, Chair Yeager. On behalf of the Nevada Police Union, my name is Eddie Ableser, E-D-D-I-E-A-B-L-E-S-E-R. The members of the Nevada Police Union want to thank Attorney General Ford and his dynamic staff for all of their hard work in reaching out and connecting with various groups across the state for Senate Assembly Bill 50. We appreciate the work that his team has done. And on behalf of the Nevada Police Union and our 900 plus members in the state, we call in support for this bill. Thank you.
Thank you for your testimony, Mr. Ableser. BPS, next caller, please.
Thank you. Would the caller with the last 3 digits of 556 press star 6 to unmute yourself and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Anne Marie Grant, A-N-N-E-M-A-R-I-E-G-R-A-N-T, Sister Thomas Purdy, killed by Reno Police and Washoe County Sheriff's Office. I support the bill, though I do believe no-knock warrants need to be abolished completely. I look at no-knock warrants as death warrants. In theory, no-knock raids are supposed to be used only in the most dangerous situations. But what people don't realize or are not told is how infrequently police get killed when they do bust into a suspected criminal's home unannounced. 26 years before Brianna Taylor's officers executed a no-knock warrant at the home of a suspected drug dealer. Officers entered apartment 2L instead of apartment 3L and tackled a 75-year-old reverend named Asseline Williams. Williams suffered heart failure and died during the raid. On May 16, 2003, 12 NYPD officers stormed the apartment of Alberta Sproul. On a no-knock warrant, before entering, they tossed a flash grenade. The boom stunned Alberta. She died 2 hours later from a heart attack. On November 21st, 2006, 3 plainclothes officers of Atlanta PD broke down the door of 92-year-old Catherine Johnston, a retiree living alone. She fired 1 shot from her rusty revolver at the intruders. The officers responded with 39 shots, 5 or 6 of which hit Catherine. The officers handcuffed her as she was dying. The list continues on. A 7-year-old Diana Stanley Jones was killed. During a no-knock warrant, at least 81 civilians died executing these type of search warrants from 2010 through 2016. These numbers only include deaths. They do not include people who have been permanently injured or wounded or have property damage as a result of these raids. I do support the bill because it's a start and a step in the right direction. Thank you.
Thank you for your testimony, Ms. Grant. BPS, could we take the next caller in support, please?
Yes. Would the caller, user 1, please slowly state and spell your name for the record? You will have 2 minutes and may begin.
Hello, Mr. Chair, members of the committee. This is Chuck Callaway, C-A-L-L-A-W-A-Y, representing the Las Vegas Metropolitan Police Department. We want to thank the Attorney General's office for including us in the working group. I think that was a very beneficial way for us to work out the details of this bill. We are in support. I did just want to put on the record in the Senate and also today in the Assembly, the lines sometimes tend to get a little blurred between a no-knock warrant and a tactical entry, such as a SWAT team would do in a hostage situation. And I just wanted the record to reflect that those are 2 entirely separate things, that a no-knock warrant does not necessarily equate to a tactical entry. But we are in support, and we thank the Attorney General for including us. Thank you.
Thank you for your testimony, Mr. Callaway. BPS, let's take the next caller in support, please.
Thank you, Chair. We'll now move on to the caller with the last 3 digits of 668. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair, members of the committee. My name is Troyce Crumme, Troyce-Krumme, representing the Las Vegas Police Managers and Supervisors Association, who represent the sergeants, lieutenants, and captains for the Las Vegas Metropolitan Police Department. We'd like to thank the Attorney General for his invite to take part in the working group. We think it was an effective group and feel that the changes and the amendment to address the exclusionary rule for allowing a thorough review to ensure that warrants that meet the Fourth Amendment but might have an issue on the no-knock side would still be authorized to have that evidence in. We feel that that was a genuine amendment. We feel enhanced oversight over no-knock warrants because of the danger involved in them is the right way to go in the state of Nevada, and we encourage your support. Thank you.
Thank you, Mr. Crumme. BPS, could we take the next caller, please?
Yes, to testify in support of Senate Bill 50, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I will close testimony in support. I'll now open it up for testimony in opposition. We don't have anyone here with us in Carson City in opposition. We don't have anyone on the Zoom in opposition. BPS, do we have anyone on the phone lines who'd like to testify in opposition?
To testify in opposition of Senate Bill 50, press star 9 now to take your place in the queue. Once again, to testify in opposition of Senate Bill 50, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close opposition testimony now. I'll open neutral testimony. We don't have any neutral here in Carson City. We don't have anyone on the Zoom in neutral. BPS, is there anyone on the phone line in neutral, please?
To testify in the neutral position on Senate Bill 50, press star 9 now. Once again, to testify in the neutral position on Senate Bill 50, press star 9 now. Chair, there are no callers in the queue.
Thank you, BPS. I will close neutral testimony. I will now invite Attorney General Ford to come back to the table for any concluding remarks on Senate Bill 50.
Thank you, Mr. Chair. Your Attorney General, Aaron Ford, for the record. Thank you again for entertaining this bill. It's important. And again, I think the unanimity coming out of the other chamber demonstrates that we're listening. I hope that we can get comparable support from this committee and from the chair in that regard. I also want to indicate that I got an email from the NAACP, Reno Sparks, who wanted to also voice their support for the bill. So if there are no other questions, I say thank you so much and have a great afternoon. Great morning.
Thank you, Attorney General Ford. Again, thank you for your work on this, and I think we've seen the magic of pizza and coffee and a locked room. I would probably recommend donuts if you're going to invite me to the next one, but food and caffeine always is the trick. So thank you again to you and your staff for this bill, and thanks to all who participated in those working groups. With that, I'll close the hearing on Senate Bill 50. We'll now go to our second bill listed on the agenda, and I'll open the hearing on Senate Bill 62 in its first reprint. That measure revises provisions relating to the solicitation of contributions. Good to see you again, Ms. Adair. Mr. George, when you're ready, please present Senate Bill 62, and then we'll see if we have some questions. Or Mr. George, are you sticking with us or are you leaving? Okay, I wanted to make sure. Okay. All right, have a good day. So, Ms. Adair, it looks like it's just you on this one, so please go ahead and then we'll have some questions.
Thank you, Chair Yeager, Jessica Adair for the record, and they are missing out because this is a fun one. No, I apologize. AG Ford has to go monitor a court hearing that is starting in just 10 minutes. So thank you so much for hearing this bill, Senate Bill 62. Senate Bill 62 is a bill intended to increase transparency of organizations soliciting charitable contributions in Nevada and give the state additional tools to fight charity fraud. First, I want to express my deep gratitude to the Deputy Secretary of State, Kim Parandi, and the entire Secretary of State's office and Secretary of State Sagaski for their assistance in the formulation of this bill. It has undoubtedly improved the bill so it best serves the state and our mutual goals to promote transparency and trust. Before I begin discussing the text of the bill, I just want to give some brief background. Charitable giving is one of the most important financial transactions of our society. U.S. donors in 2019 gave more than $449 billion, with a B, to charity, with 69% of funds coming directly from individuals, according to the National Philanthropic Trust. Charitable giving allows nonprofit organizations to serve important causes and those in need, and allows an individual to express their wishes, benevolence, and even religious faith by supporting causes close to their hearts. Unfortunately, there are those who seek to exploit the generosity of others for their own greed. Charitable organizations registered with the IRS as a 501c3 organization must submit lengthy verification and documentation to demonstrate that the organization is organized and operated exclusively for charitable, religious, educational, scientific, literary, or other approved purposes. It must not be organized or operated for the benefit of private interests, and no part of the net earnings may inure to the benefit of any private shareholder or individual. Fraudulent organizations clearly cannot meet this threshold, so many turn to other kinds of entities that are easily formed and simply call it a charity. Common examples of these entities include PACs and LLCs. You are probably familiar with PACs, or political action committees. While most PACs serve a legitimate political purpose, there are those who use the more relaxed registration requirements to masquerade as a charity, solicit contributions from well-meaning people, and then pocket the cash. They often choose misleading names that sound like charities, or even use slightly modified versions of a name of an existing charity to take advantage of the public goodwill of a legitimate organization. Our office receives complaints regarding charity fraud, particularly after a disaster when people are vulnerable and others seek to assist them. Yet these scam organizations can escape our jurisdiction and punishment. At the federal level, the IRS cannot revoke the tax-exempt status of an organization that never registered as a 501c3 in the first place. Under NRS 598.1305, the Office of the Attorney General has jurisdiction under the Deceptive Trade Practices Act to prosecute charities that make false claims in their solicitations. But, and here's the key part, this section only applies to organizations, quote, who the Secretary of the Treasury has determined to be tax exempt pursuant to the provisions of the 501c3 of the Internal Revenue Code, end quote. Even an organization is not a 501c3, the statute does not apply, and we don't have jurisdiction. This is the problem we are trying to solve with this bill. Scam charities do not serve the public, dupe well-meaning people out of their money, and put legitimate charities at a disadvantage. So turning to the bill, Section 1 of the bill expands the definition of a charity to include any organization that is or purports to be established for any benevolent, philanthropic, patriotic, educational, humane, scientific, public health, environmental conservation, civic, or other eleemosynary purpose, or the benefit of law enforcement, firefighting, or other public safety personnel, or in any manner employs a charitable appeal as the basis of any solicitation, or an appeal that suggests there is a charitable reason for the solicitation. The purpose of this is to require all charities, not just 501c3 organizations, to register with the Secretary of State. This information is then available to the public as a business entity, searchable on the Secretary's Silver Flume website. Charities are also required to file an annual financial report with the Secretary of State with extremely basic information that would normally be included on a charity's 990 form with the IRS. It is as simple as one single page. Section 2 clarifies that a contribution does not include bona fide fees or membership dues, that this is not intended to apply to clubs or hobby organizations, people who pay a due to be a member of a club and they're not actively soliciting charitable contributions from the general public. It also clarifies that a contribution does not have to be tax deductible. Donations to PACs or chipping into an LLC is clearly not tax deductible. Sections 3 and 4 make conforming changes. Section 5 makes conforming changes to what an organization is required to report that reflect the types of organizations has been expanded. And Section 6 and 7 also make conforming changes. Section 8 expands the jurisdiction of the Secretary of State and the Attorney General to refer and prosecute violations of the DTPA for false statements when soliciting contributions to all charitable organizations, not just those who are 501c3 organizations. And Section 9 makes conforming changes. And that is all I have for the bill presentation today, and I am happy to take any questions.
Thank you, Ms. Adair. We're going to take our first question from Assemblyman Wheeler.
Thank you, Mr. Speaker. I just wanted to compliment Ms. Adair on the wording on page 2, line 14, eleemosynary. And I wanted to let you know I went back and after the chairman put it up on Twitter last night, I went and looked at my word of the day calendar and it wasn't in there, so I added a page to May 6th, and that is now my new word of the day, and I wanted to thank you for that.
Thank you, Assemblyman Jessica Adair. For the record, I have to give credit to LCB. That is their drafting, and I completely butchered the pronunciation of that word when this bill was heard on the Senate side.
I am happy to report that you did pronounce it correctly. This time I had to ask legal counsel how to pronounce that word, and I'm assuming that probably nobody else on the committee had heard that word, and you'd be interested to know that it is actually in our state constitution. That's where the word comes from, and it's in the same sentence as perpetuities. So was it Article 14? Is that where it was? I can't remember. We'll find that site for you, but that is definitely the word of the day, so I challenge everyone on the committee to try to use the word eleemosynary at some point today, and you'll get confused looks from our colleagues, I'm sure. Do we have additional questions from committee members? Assemblyman Orntlicher.
Thank you, Chair. Thank you, Ms. Adair, for bringing this to us, and David Orntlicher, Assembly District 20. So I just want to Section 1.2, the exclusion for religious purposes, I just want to make sure I'm understanding that. Because if you look at the definition that the Secretary of Treasury that you cite, Section 501c3, that does include religious. So it looks like, so what you're saying is even though the IRS allows religious, we're not going to. And while I understand and separation of church and state, recent Supreme Court decisions suggest that may not be permissible. So is that what this is doing, or is it doing something different?
Thank you, Assemblyman Jessica Dare, for the record. So that language in the bill is existing Nevada state law. So we're not seeking to change state laws that it applies, but because religious organizations often do file as a 501c3, they're already covered. So in Section 1A, they are already required to register with the Secretary of State as a 501c3 organization, and that's not what we're not trying to change any of that status currently.
Go next to a question from Assemblywoman Krasner.
Thank you, Chair Yeager. Thank you, Ms. Adair. So I just had a quick question. The bill expands the type of organizations required to register with the Secretary of State as charitable organizations. And then in Section 1, Sub 1, it says charitable organization means any person who directly or indirectly solicits contributions. So I'm just wondering, the little girl and her sister who start up a lemonade stand in their front yard to raise money for the poor, are they going to be caught up in this? Thank you, and have to register with the Secretary of State?
Thank you, Assemblywoman, for the question, because Jessica Dare, for the record, we wanted to make sure that didn't happen. So there is current regulation already under the Secretary of State regs that exclude those very small mom and pop lemonade stands. So we're not seeking to change any of those current regs, and that because that was very important to us. What we're trying to do, though, is capture, and the reason it's a person is because the individual will file as an officer of that organization with the Secretary of State. But no, we're not seeking to expand the definition to those existing small organizations.
Thank you.
Do we have additional questions from committee members? Assemblywoman Kasama.
Thank you, Assemblywoman Kasama from District 2. Thank you again for all your presentations today. I guess my question is, it seems to me that we're starting a whole new area of people filing, and we're probably, a lot of people don't know they need to file, and it just seems to me that the bad actors aren't going to file. And so it seems like there's just a whole bunch of policy and regulation that I don't think is needed, because it's the bad actors aren't going to come and do that, and then you're still going to get complaints from them. And we know there's so many organizations. I mean, everybody puts military or something for their organization looking for money and as you said, prying, on emotions from people. So I guess I'm trying to think of how this, in the big picture, you think this will help.
Thank you for the question, Assemblywoman Jessica Adair, for the record. You're right. We don't expect scam organizations to register. But because of that, in this bill, we can then go after those organizations for failure to register. So when we get complaints from an individual who said, hey, I got this solicitation who says that they're raising money for Las Vegas Metro, but it's not the Las Vegas Metropolitan Police Foundation. It's some other random organization. And we go and we look through the Secretary of State's website, and we don't see it. And we talk to the Secretary of State. They're not registered. Because that organization is soliciting and would be required to register under this law, and they haven't registered, we can then take action against that organization for the act of not registering. And let's say they do register and they start making false solicitations, then we can go after them for the DTPA violation. I think you're right. Criminals don't follow the law. But That's why we designed the law, to ensure that we have the tools to then go after those who don't abide by the existing law. And also, I misspoke when I answered Assemblywoman Krasner's question. I said regulation. I meant law, and it's in Section 4 in its existing law. There are existing statutes in the law that are exceptions for small organizations, and it is currently in the bill in Section 4, and I apologize for misspeaking on that.
Additional questions? Assemblywoman Hanson.
Thank you, Chair. And thank you, Ms. Adair, for being here and helping us to understand this bill. Along those lines of what you were just answering to my colleague, that you would be able to go after them. I'm just curious how, because I've had these calls, and I've actually even forwarded stuff to the Attorney General's office. How do you find them? Are you able? Do you feel confident that you're going to be able to go after these scammers?
Thank you, Assemblywoman Jessica Adair, for the record. Yes, and we do rely on those constituent complaints. We're a complaint-driven office. We're not going to be able to conduct sting operations, for example, on these types of organizations. But we do get these complaints, and right now it is so frustrating for our office to not be able to do anything about the Americans for America organization that's raising money for cancer research. And we know that they're not a legitimate organization, and that people think that they're donating to a legitimate organization that would, assist in cancer research. So yes, I believe that we will. And working with the Secretary of State on this bill, they are very interested in working on these issues as well, because it serves us all. And we'd be happy to receive those complaints, but I cannot tell you how frustrating it is for our office to know that there's nothing that we can do under the current law if they are not an actual charity.
Other questions? I don't think we have other questions. I did want to let the committee know I found the section in the Constitution. It is Article 15, Miscellaneous Provisions, which is a quite fascinating part of our Constitution. It establishes Carson City as a seat of government. It has term limits. It indicates when the general election should happen, and also indicates that the number of legislators shall never exceed 75. But most importantly, in Section 4, this is the entirety of the provision. No perpetuities shall be allowed except for eleemosynary purposes. So that's where the language came from.
Thank you, Chair. I believe I deserve a donut for correctly pronouncing the word. And I'm sure Assemblywoman Torres is very sad that she missed yet another discussion on the rule against perpetuities. So.
Thank you, Ms. Adair. Appreciate it. We will now take some testimony on Senate Bill 62. We'll start with testimony in support. There's nobody left here in Carson City in the audience. I don't think there's anyone left on the Zoom. BPS, could we go to the phones to see if there's anybody there in support?
Yes, Chair. To testify in support of Senate Bill 62, press star 9 now to take your place in the queue. Once more, to testify in support of Senate Bill 62, press star 9 to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close testimony in support. I will now open testimony in opposition. Again, we don't have anyone left in the audience here in Carson City. We don't have anyone on the Zoom. I believe we have a few folks on the phone who would like to testify in opposition. BPS, could we go to the phone lines and take the first caller, please?
To testify in opposition of Senate Bill 62, press star 9 now to take your place in the queue. And we will begin opposition testimony with the caller with the last 3 digits of 859. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Mr. Chairman and members of the committee. My name is Janine Hansen, Janine INEHANSEN. I'm the state president of Nevada Families for Freedom. We oppose SB 62, requiring many additional nonprofit organizations to register and provide financial information to the Secretary of State. Registering these nonprofit organizations is the first step before requiring nonprofits to disclose their donors, which will expose them to the cancel culture, intimidation, retaliation, harassment, and violence. This has already happened in California. The law in California is being challenged in court by Americans for Prosperity, which filed against the Attorney General, Xavier Becerra, which requires charities and tax-exempt nonprofit organizations to provide the government with names and addresses of donors. Robert Alt of the Buckeye Institute, who is one of the attorneys for the lawsuit, said, "In fact, it is an alarming violation of the First Amendment right to free association and would have a chilling effect on free speech." Courts have consistently held that forced disclosure of donors can threaten freedom of association since the ruling in the landmark 1958 NAACP case. The brief in California argues that freedom of association is threatened because of potential retaliation and additional scrutiny from the government if certain officials disagree with the mission of the nonprofit. AFP and its donors could be a potential target of retaliation because of the nonprofit often takes stances against the government. As I repeat, this bill, SB 62, is the first step toward what they're doing in California. It will pave the way for the same kind of government overreach, subjecting donors to the cancel culture, intimidation, retaliation, harassment, and violence. We don't want or need more government policing of our charitable giving. Don't interfere with our freedom. Thank you very much.
Thank you for your testimony, Ms. Hansen. BPS, do we have additional callers in opposition?
Yes, we do. With the caller with the last three digits of 319, slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair and members of the committee. My name is Melissa Clement with Nevada Right to Life, testifying in opposition to SB 62. While I understand the desire to protect the public from scam charitable organizations, we are rightly concerned that this could be used in future sessions and in the future to require organizations, 501c4s, PACs, etc., to disclose their donors. This has been used in California and other locations to dox donors who hold opinions contrary to special interests. This threatens freedom of speech and freedom of association. In recent months, we have seen individuals losing their jobs, being threatened for holding opinions that vary on life, liberty, election integrity, and any other manner of topics. And for this reason, we oppose SB 261. Thank you so much.
Thank you for your testimony, Ms. Clement. BPS, are there additional callers in opposition?
Yes, Chair. We'll now move to the caller with the last three digits of 373. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Yeah, good morning. My name is Bob Russo. That is Bobrusso. And I oppose Senate Bill 62. I'll say first off, ditto to Janine Hansen's testimony. And I will say that I have the same concerns regarding the potential for government overreach with the potential for disclosure of donors. The government overstepping its constitutional limits is nothing new. We saw this in play when Judicial Watch obtained IRS documents proving that the Obama administration ordered that agency to target and destroy conservative organizations. According to an article in News Punch from April 5th, 2017, quote, nearly 700 pages of Obama IRS scandal documents showed that officials working under Obama used inappropriate political labels to have conservative tax-exempt organizations receive unfair treatment by the IRS. Government overreach, be it on the federal or state level, is a threat to the liberty of Americans and must be avoided. Senate Bill 62 would encourage this overreach, so I urge you to please oppose it. Thank you very much.
Thank you for your testimony, Mr. Russo. BPS, could we take the next caller in opposition, please?
Yes, with the caller with the last three digits of 105, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning. My name is Lynn Chapman, LYNNCHAPMAN. I'm the State Vice President of Nevada Eagle Forum. We oppose SB 62. The people of this great country have always come together to speak, to discuss, to debate, and to celebrate on just about anything and everything. We have always known how important it is to be able to do that. We sometimes come together in organizations and sometimes not so organized. But it seems that our state government wants to stifle our free thought and free speech and our gatherings. The more we want to enjoy our freedoms and liberties, the more government wants to regulate them and have us report everything about our lives, even our giving to charities. We have concerns about where this reporting and regulating can be leading us and where we can end up, such as having to disclose a list of our donors. A quote from Thomas Jefferson, quote, "The care of human life and happiness and not their destruction is the first and only legitimate object of good government," unquote. We are not happy with this bill. Please oppose SB 62. Thank you.
Thank you for your testimony, Ms. Chapman. BPS, are there additional callers in opposition?
To provide opposition testimony to Senate Bill 62, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close opposition testimony. I'll now go to neutral testimony. Seeing nobody here in Carson City, seeing no one on Zoom. BPS, could we go back to the phones to see if there's any neutral testimony, please?
To provide neutral testimony on Senate Bill 62, press star 9 now to take your place in the queue. And we will go with the first caller with the last 3 digits of 101. Press star 6 to unmute yourself, and then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the committee. My name is Kim Perondi. It's KIMPERONDI, and I serve as Deputy Secretary of State for Commercial Recordings. You may have already seen my comments as they were posted to Nellis while in Senate Judiciary, but we just wanted to put this on record here as well. The Secretary of State's Commercial Recordings Division is a filing office for official records and is responsible for the processing and recording of organizational and amendatory documents of business entities pursuant to the laws of the state of Nevada under NRS Title VII. Legislation was originally crafted in 2013 requiring Nevada nonprofits under Chapter 82 to register with our office before soliciting charitable contributions. In 2015, these requirements were placed under Chapter 82A and expanded to include in-state and out-of-state organizations. And I will note there are some exemptions listed as was previously discussed by Ms. Adair. The existing filing requirements in Chapter 82A include the name of the organization, their jurisdiction, place of business, their purpose, names of their officers, directors, and executive personnel, and certain federal tax status and financial report information. There is no fee to file these documents, and these documents are recorded in our database and available to the public at no charge. I thank Ms. Jessica Adair for bringing Senate Bill 62 to our attention in its draft stage for review and comment. The proposed changes to Chapter 82A under this bill cause no deviation to our current filing process, nor do we anticipate any fiscal impact to our office. It is possible the expanded definition may cause an increase in the number of filings our office processes, as well as the number of inquiries and investigations of complaints. However, at this time, we don't expect that to be enormous or unmanageable. We do work closely with the Attorney General's office in referring and prosecuting fraudulent soliciting activities. So therefore, the Secretary of State's office is neutral on this bill. Thank you very much.
Thank you for your testimony, Ms. Perondi, and thank you for your patience this morning as we got to this bill. BPS, are there additional callers in the neutral position?
To testify in the neutral position on Senate Bill 62, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close neutral testimony. Invite Ms. Adair back to the table for any concluding remarks on Senate Bill 62.
Thank you, Chair. Jessica Adair for the record, and thank you for the opportunity to make some concluding remarks, because I was very surprised to hear the opposition today. This is the first we've learned of this opposition, and if you're still on the line, folks, opposition folks, I really wish you had come to our office before the hearing so we could have talked about your concerns. I want to make a lot of clarifications here, because what the testimony in opposition, I think, results in a serious misunderstanding of this bill. First of all, this bill did not come from legislation from California. It came from model legislation from Ohio. Ohio has a scan pack law that we thought was a great example of what states can do in this realm, and we modeled our legislation after that. Deputy Secretary Pirandi just testified as to the financial requirements that must be listed when filing, but if you're interested, members of the committee, it is on page 6 of the bill. It is very simple, and it contains absolutely no information that is related to donors. None. Not a single thing. I will note that many of the folks who were testifying in opposition talked about donor information requirements as they relate to 501c3s and PACs. This bill doesn't change anything as it relates to 501c3s and PACs. As members of this committee probably know very intimately, PACs have significant reporting requirements as it pertains to donors. There's a lot of transparency required in terms of donations to and from PACs. This bill does not change anything, and if you notice in the listing of types of organizations to require, there is the word political is not included. In terms of the types of organizations. 501c3s also have donor reporting requirements. Those are confidential and they go to the IRS. This bill does not change anything as it pertains to 501c3s. And frankly, the purpose of this bill pertains to 501c3s at all. 501c3s are legitimate charity organizations. That's not what we're concerned with. What we're concerned with are organizations that register as organizations beyond 501c3s that say that they are a charity and solicit charitable contributions from the general public. That is what we're concerned with here. If the members of the committee are concerned that this bill could be used to obtain donor information, I would encourage you to read the bill. If you have any questions about the text of the bill, its intent, please don't hesitate to contact me or the Secretary of State's office. But I want to be extremely clear that there is nothing in this bill that pertains to donor information. If the committee has any questions here or offline, I am happy to make myself available. Thank you.
Thank you, Ms. Adair. We're going to take just a couple quick questions for you. We'll have Assemblywoman Hanson and then Assemblywoman Kasama.
Thank you, Chair, for another chance, and thank you, Ms. Adair, for that clarification. It was very helpful. Just in Section 1, down in sub 3B, and I probably should have asked this earlier, but now that you mentioned a couple things, it made me think of it. What is the definition of patriotic, then, if we're kind of talking not political or things like that? What would that mean?
Thank you, Assemblywoman Jessica Adair, for the record. So we don't define patriotic, and because we don't want to be too over-inclusive or under-inclusive. So I would take the plain meaning, and so the Americas for American organization wants you to chip in to help America, right? So, but, if what we're concerned about, though, if it's a PAC, so I think that might be where you're headed, right? If it is a PAC, they're already required to register with the Secretary of State as a PAC. But here's what our problem is with those organizations. A PAC is not subject to our jurisdiction for Deceptive Trade Practices Act for false statements when soliciting charitable contributions. So if a PAC is soliciting political contributions, great, wonderful. They fall under the Secretary of State's authority for appropriate political contributions to that PAC. and there are so many requirements that they have to follow. But if a PAC is not soliciting political contributions and they're soliciting charitable contributions that they say will be used for putting up flags outside of a business or down the street, and then they don't do that, they just take the money themselves, that is a lie. It's a misleading statement in order to solicit that charitable contribution. That is a really long answer to your very simple question, but I want to make really clear that there's already a lot of registration and reporting requirements as they pertain to political organizations. It's not what we're trying to get into, and we don't need to add to that. What we do need is DTPA jurisdiction for those scam organizations that will make it more difficult for some of the organizations that testified today.
Thanks.
Assemblywoman Kasama.
Thank you. For the record, Assemblywoman Kasama, District 2. So I read through that section 4 again on page 5 where you talked about, this small little groups would be exempt. But as I read through that, it says fewer than 15 persons. So, if the school has a fundraiser and the child is selling cookies, and, I used to do that with my kids, or selling candles, and you go to everybody in the office or whatever, and you try and get some funds. But many times, the goal was to get 20, 25, 30, and they win a prize if they have 50 people and they're just selling the candles or the cookies. It seems to me that they would have to register now. Is that correct?
Thank you for the question, Jessica Adair. For the record, no. The charity organization, however, that they are raising money for does need to register. So if they are raising money for the Susan G. Komen Foundation, they're already 501c3, but for example, they would register, right? So those kids are just agents of that organization that is soliciting contributions. And I also want to be clear that if the contributions are directed to only people who are within your family. So if you're doing a fundraiser for someone's medical expenses, that's not what we're trying to capture here. I think these are important exceptions so we don't catch up the folks who are just trying to do a good deed. But what we're really after here are those scams.
Thank you.
Okay, and we're going to leave it there, committee, given the time. If you do have additional questions for Ms. Adair, please feel free to reach out offline. Thank you for spending your morning with us, Ms. Adair. We hope you have a great rest of the day. I'm going to close the hearing on Senate Bill 62. That takes us to our last item on this morning's agenda, which is public comment. We reserve up to 30 minutes for public comment at the end of each meeting. Public commenters will have 2 minutes to provide public comment. Public comment is a time to raise matters of a general nature within the jurisdiction of the Assembly Judiciary Committee. Do we have anyone with us in the room here in Carson City for public comment? I don't see anyone coming forward. We don't have anyone else on the Zoom. BPS, could we go to the phone lines for public comment, please?
If you're wishing to make public comment, please press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 556. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIEGRANT, sister of Thomas Purdy, murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. Today I'd like to talk about Stanley Gibson. Stanley Levon Gibson was born in Las Vegas and was a lifelong resident. He served in the U.S. Army during the First Gulf War and was a decorated soldier, receiving medals including the Army Good Conduct Medal, Army Service Ribbon, Saudi Arabia Kuwait Liberation Medal, Southwest Asia Medal, and the National Defense Service Medal. He had an honorable discharge. His mother had to bury her son. His wife had to bury her partner of 11 years. Not only do police murders of community members weaken the public's trust in law enforcement, but it is the community and the taxpayers who ultimately pay for these bad actors. Stanley was 43 years old when he was shot and killed by LVMPD officer Jesus Aravello in the early morning hours of December 12, 2011. An inferior police plan to force Stanley out of his car led to the shooting. The officer erroneously thought he was being shot and returned fire. He fired 7 shots into Stanley's Cadillac. His wife, Rhonda, said he suffered from post-traumatic stress disorder from his time proudly and bravely serving our country during the Gulf War. Stanley Gibson was unarmed. His jacket would later be returned to his wife, riddled with bullet holes and his service medal still attached to his jacket. I don't think the general public is aware of how many veterans are killed by police while in crisis. Stanley was killed less than 2 years after 21-year-old unarmed Trayvon Cole, who was shot by LVMPD in his apartment bathroom. Stanley's murder is a perfect example of how the mental health care system failed. Stanley had been arrested 2 days prior and was ordered to have a psych eval done at the jail. That never took place, and he was released. These unnecessary murders by police have been occurring for far too long in Nevada. I would just like to mention Ronald Vendejas was killed May 4th, 2020 by RPD and SPD. Washoe DA Chris Hicks has yet to release his OIS report. Over a year later, his family and his community wait for the report and the body cam footage. Please support bills that promote transparency and accountability from law enforcement. Thank you.
Thank you for your public comment, Ms. Grant. BPS, are there additional callers for public comment?
If you would like to make public comment, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. Appreciate your help. As always, I'll close public comment. Anything else from committee members this morning? I don't see anything. Just as a reminder, tomorrow we have a meeting at 9 o'clock. There is a work session planned for tomorrow. As of today, we've heard all the bills that are within our committee. I do believe we'll be getting more bills potentially, but as of now, we don't have any more left. So tomorrow we'll be doing a work session starting at 9. A reminder that we'll have donuts available in my office at 8 o'clock. So if you get here early, please stop by for that. I don't yet know what next week holds for us, but I'll have more information for you tomorrow. And with that behind us, thank you, committee, for your attention and hard work. And please go forward in an eleemosynary spirit. We'll see you here tomorrow at 9 a.m. This meeting is adjourned.